completely participative. Hope all of you agree, right? I didn't hear any voice.
Yes, sir.
So my humble request would be let's be very participative and keep on asking, sharing thoughts among each other so that we make the session interesting, learning, and we can build on it. So what I'm going to do is I'm just sharing my screen, and once you say that yes, my screen is visible to you, I would go ahead. Is my screen visible?
Yes, sir.
Yes.
All right. So today evening, what we are going to do today is we are recapping and relearning our understanding around financial service providers. And I would keep the session conversation two-way because I'm dealing with my peers in multiple professions altogether. And it has to be exchange of ideas along with learning. So the first and foremost thing that comes to my mind when I start a session, that what is the need of a financial service providers having a separate domain for insolvency? That is the first question that comes to my mind. And I would like to hear, might be from all of you or might be from some of you, what are your thoughts around it? Let's discuss the conversion. Let's open the floor first. Yeah, any volunteer or should I name? Mr. Sanjay? Mr. Sanjay Kathane, would you like to share your thoughts on that? Hope guys I am audible, right?
Yes, you are audible.
So okay. So let me just start that. So before we further move into this is our lovely preamble of IBC which I used to show, and developing entrepreneurship always is a foray of IBC, and that's why we keep on studying and experimenting with IBC on day and day long. What we will discuss, our topic today that we are going to deliberate is a very smaller one with a very wide impact. Impact is very wide impact. So we would be talking about some of the definitions here very briefly. And then we would be talking about a particular section that you will see in the subsequent slide here. So IBC is divided into 5 parts. We are not touching other parts. We are talking about definitions, and then we are talking about a specific section dealing with FSP. Now, my first task is to make all of us understand very clearly why we need a separate framework for FSPs. For that, we need to know who are the FSPs. So, at this moment, we can presume banks are FSPs. We'll see much in detail in the subsequent slide. So, what happened? Bank is a big finance utility for public at large. And whenever you think of or hear of a bank getting insolvent or bank going into liquidation, it has got a serious impact. One is, large database, large size of depositors, large quantum of depositors are involved. They become your creditors. A normal procedure will not work for sure. Because it will not work for sure, you need to have a separate regime for financial service provider, that is banker, for this particular slide. If a bank, just think, I wish it should never happen. Just think that somebody say that State Bank of India is going into insolvency. What would happen in the country? It would have a much larger impact than monetization, demonetization. There would be hue and cry altogether. Out of 140 crores of people, I'm sure about 10 crores plus people have banking relationship with the State Bank of India. What will happen? It would have a dynamo effect. What will impact State Bank of India? It will impact all the ancillary services related to it. So it become a very scary situation. You have a very systemic financial sector, and then companies which are too big to fail. If they collapse, it would have a impact of spreading. It is called contagion effect. It will spread all around. So we need to have controls, checks, and a very specific process on that. And on the top of it, if a banking institution fails, what will happen? Will people have trust in the system? Your trust will evaporate. Then again, what people will do? They will not keep their deposits with bankers. They will tend to go with the local person who are moving around their streets. Means whole banking sector getting collapsed. Another very important thing is that there's a large number of retail consumers which are involved as a financial service availers, and those services would need to be curtailed if they go for insolvency. So it has a very wider impact. Now, on coming to the creator side, banks have usually have a much larger creator numbers, and handling those numbers that might run into crores or millions, I would say, is cannot be handled with the normal process of IBC that we see in CIRP processes or liquidation processes or voluntary liquidation processes, because they are meant for limited number of creditors, say 1,000 creditor or 2,000 creditor at a max. That is how the system can cater to. But what IBC's general prescription is, it cannot cater to millions or crores of creditors under one umbrella, under one scheme of IBC. Certainly, normal schemes will not work. So you need a separate framework. So anybody who is having a different argument or point of view that no, the normal procedures or normal regime of section 7, 9, and 10 would work. Anybody would like to add here? Anyone? Hope I'm encouraging you enough to speak up and share your thoughts. Okay, let's move on. Now, before we go into deeper details, we just see a little background around FSP, financial service provider. So this is a very favorite term of ours. So we generally call it CD. Who is a CD? Is a corporate person who owns a debt to any person. Now, who is a corporate person? That's where everything lies. So I'll just read out the definition for you. Corporate person is a person, means a company as defined in clause 20 of section 2 of Companies Act 2013. A LLP as defined in section subsection of LLP Act, or any other person incorporated with limited liability. So there are three things: company, LLP, and any other entity with a limited liability under any law in force, but does not include financial service provider. So by the very basic definition of corporate person, IBC excluded financial service provider from its ambit. That's why we hear in general that NBFCs or stockbrokers cannot be brought into under umbrella of IBC. Now there is a catch. Now what is the catch is, by a indirect method, government applied IBC with lot of modification on financial service provider. How? So This is section 227 is the mother section for financial service provider. This section empowers central government to notify what all financial service sector providers can come under ambit of IPC. We will see who will advise, then who to include, who not to include. All those things have been empowered by to central government by this particular section of IBC, section 227. We will see this section in much larger details in subsequent slide. This section empowers government to prescribe that the procedures given in IBC can be applied with as much modification or such modification as are required to meet the very purpose. Adding to this, we saw this that corporate person excludes.
तरी आपण एकत्र यायला हवं तर म्हणल्या होत्या तू एकदा बोलून घे.
Excuse me, excuse me.
मी
If you
त्यांना
are,
सांगितलं की तुम्ही
should we continue? Okay, all right. Now, this particular section 227 was operationalized on 1st of May 2018. Before that, this section was in code but was not operationalized. It happened after almost after 2 years of making IVC relevant. After making section 229, 227 operationalized, central government exercises power on November 15, 2019. These dates are very important. We'll see in subsequent slides how these dates become very important. And they rolled out under this under the powers of section 227 and 239. They rolled out rules for insolvency resolution and liquidation of financial service providers. These rules came into place. Now, in the previous slide, we spoke about just presume FSPs are banks. But here, there is a catch. The rules prescribe very clearly, very sharply, that these rules are not applicable to banks. It means there is a very restricted and limited application of financial service providers under IPC. Because banks are not covered, banks are covered by specifically Banking Regulation Act. And a wider framework for liquidation or insolvency of banks is yet to be published. So banks are not covered. There are other than bank financial service providers are covered. We will see in subsequent slide what are those. And these rules prescribe that what categories of FSPs would be notified by central government from time to time. And central government has prescribed it also slowly. To my mind, with a country as large as ours, definitely framework given in under section 227 for limited application is only an interim mechanism, is not a full-fledged solution because it does not deal with banks. It has a lot of caveats and it has a lot of involvement of regulators. We will see in subsequent slides. Now, I have one question for all of you. So far, we spoke about rules. We saw code. Generally, what we see that in IBC, you have regulations altogether. Surprisingly, there is no regulation on insolvency of financial institute of financial service providers in IBC. There is no regulation. Can anybody throw light on it? Why there is no regulation? Any one of you? Guys, we are in workshop. We have to be participative. Mr. Mahesh, you are only visible. Would you like to throw some light?
No, sir. Please go ahead, sir.
Pardon?
you please go ahead. I want to learn because I don't know about this subject.
Okay, all right.
Yeah.
So the interesting piece is,
Sir,
and
might be, sir, can I say here something, sir?
yeah, of course, sir, we are here to,
Yeah.
well,
Sir, as you said that like these are not applicable to the banks. So like there is a separate regulation for the bank. Might be in the thought process of the framers of this rule that like the respective acts will apply to them or respective regulations will apply to them, and based on that, is that the right thing which I'm saying?
yeah, you are absolutely right from your perspective. So what you are saying is, because there is a Banking Regulation Act and IBC does not apply to banks, so then there would be procedure under Banking Regulation Act. Absolutely right.
One
But
more thing,
my
like
point,
yeah.
but
So one more thing,
my
like yeah. So the asset reconstruction companies, like just take an example. If the asset reconstruction company has to go for the CIRP process, in that case, the respective rules and regulations should be specified in the surface to really deal with that. And this should be like say must have a connection with the IBC, something like that.
not really, because you see, SURFACE is a purely recovery mechanism. And what we are discussing here is what is the
No, no,
treatment
no,
of
no,
FS?
no, no, no. Just I'll take you to the point. Any ARC which goes for the CRP process, like they are failing on that, like SRs to be
Huh.
redeemed and other. In that case, like if the ARC goes for the CRP process under the IBC, in that case they
Correct.
should have a respective regulation specifically mentioned in the say under the garb of say the surface, like then only the things
Yeah,
will
yeah.
yeah.
Yeah, you are right. You are very close. So, in fact, where I'm driving your attention to is that in IBC, who is the regulator who governs everything? You know, who has a say? It is IBBI, right? It is the Insolvency Board of India, which has a say, and all the regulations are generated, drafted, promulgated by IBBI. Am I right? There is no doubt about it. The beauty of financial service providers regime in IBC is that surprisingly IBBI have no role to play. I'm repeating, IBBI have no role to play as far as FSP piece is there, and therefore there is no regulation, because ultimately under IBC the regulations are given by IBBI, and because they don't have a role, they have not given any regulations yet. Now, why it is so, we will see in subsequent slide. But where I'm drawing your attention is, the one of the reasons why perhaps I forgot to share with you when we were discussing this particular slide, that why a separate regime for FSPs. One of the hidden thing why from the definition of corporate person FSPs were excluded was that perhaps the lawmakers did not want class of regulators. Generally FSPs are regulated by multiple regulators like Reserve Bank of India, SEBI, IRDA, that all we'll see. And they did not want that IBC is regulated by IBBI. And you have two regulators operating in one regime, what will happen? There would be class of bureaucracy, nothing else, and no solutions will come out. Perhaps this is the reason why FSPs at a first place was excluded. Now, these rules were notified on 15th of November. Now you see the speed of execution. You have the rules on 15th of November. Within 3 days, government came up with a notification. In India, usually this kind of speed is not seen. But there was a particular reason why this all happened. I'm sure all of you would have heard one finance company, Divan Housing. And Divan Housing promoters and management manipulated the fund. Lot of deposits went for a toss. and then company was in a sudden crisis. At that time, all the central government, IBBI, RBI all wake up and all these things started happening. Just to give you the background. So on 18th of November, Government of India, in consultation with Reserve Bank of India. So you will see in FSP, Reserve Bank of India have a very, very, very wide role to. So they issued a notification. What the notification says? First, that notification said that we are making the new rules to NBFCs. They did not include any other financial service provider. They just said NBFCs. Which kind of NBFCs? So they said, okay, NBFCs, which will include housing sector also. So housing finance is also included. What else? Okay, that NBFC should have asset size of 500 crore or more as per last drawn audited balance sheet. So asset size should be 500 crore or more. If it is less, then no, it cannot be brought into the umbrella of IBC. All right. Now, who would be the regulator? Because regulator is IBBI. They said no, in this financial service provider case, regulator would be Reserve Bank of India. And third thing is how to deal with the third party assets, because all the banks, NBFCs deal with third party assets. So they said, okay, we will notify it separately. And that notification came on 30th January 2020. Now we need to discuss a little more because there is a numerical piece here. It says asset side of 500 crore or more. Now, I want to test and see what is the consensus in the house today when we evaluate this value of 500 crore or more. How you will arrive at that value? What this value is? Can anybody would like to throw light on it? Is it loans and advances minus deposits? Am I making sense? Is it the value of fixed assets? What is this asset size of 500 crore or more?
It's loans and advances.
Yeah, please.
Yeah, this is related to loans and advances only.
It's only loans and advances.
Yes, yes.
So it means if a company, if a NBFC have got a huge asset base, right? Got a huge asset base. Asset means fixed asset base. Let's say they they have a big building also. They have a big piece of land also. Do you mean that will not be included here in 500 crores? Yes, gentlemen.
Yeah, it could be. We can include asset. That also we need to include. But generally, the asset says might be. We will say that's what is the business. Business is related to loans and advances. What business? What the company is having.
Yeah, correct. But when
So
it comes to
it
measurement,
seems to be like the
you know,
focus is on the financial assets only, like loans and advances here. So they might not have included the land building or plant machinery, whatever it is, like the fixed assets we are talking about.
so it is not like that. Thank you for your inputs. It's not like that. It is aggregate of asset side of balance sheet. So whatever are the total assets has to be considered for 500 crores. It is not net assets. So my point was that somebody may say, okay, you gave loans of 1,000 crores, but how you got those 1,000 crores? You borrowed 800 crores. So your net investment was only 200 crores, so you are not eligible. It's not like that. The borrowing, whatever you have borrowed is whatever is your liability has to be excluded. Only whatever is your assets, so loans you have granted, assets you have bought, investments you have placed in market, all has to be aggregated to examine whether your asset side is 500 crore or more or less. And accordingly, you will move ahead if there is a need of insolvency as per this notification. All of you agree? All right, let's move on. Now, as we just discussed, this is only an interim arrangement under Section 227. It's not that government did not attempt anything on that. There was a financial resolution and deposit insurance bill in 2017 that was passed. But that bill somehow could not be shown light because of a backlash in parliament. In this particular bill, government placed one particular thing that depositors' money can be used to settle liquidation claims. And on that, opposition parties do not agree. And then this bill was dropped. Then another bill came, FSDR, Financial Sector Development Regulation Resolution Bill. However, draft of this bill was not available. I don't know why, because currently we are in a phase of new government coming into country. And I have not seen from either parties or either political groups that this is on their agenda. But this should be, because this is the need of the hour. Might be after 1 year, government will wake up and this bill would be placed in parliament, you know, and then we can see some light on the insolvency related regulation or banking sector or financial service providers. Now let's see some of the dates to just grasp our understanding. Section 227 was operationalized on 1st May 2018. After 1.5 years, notification for FSP rules came on 15 November. And then on 18th of November, you got a notification saying what are the FSPs, what kind of FSPs would be treated into IBC. I just mentioned some time back to you what triggered. It was Diwan Housing Finance which triggered all these actions. So you see the speed of execution. On 18th of November, you have a notification of financial service FSPs coming into IBC space. And on 3rd, within 2 weeks, you have an application with NCLT for Diwan Housing Finance. So you see how much a collective effort was done at that time to solve a crisis. And then within 2 months, I would say, third party assets handling notification came. And then in January 21, you have a resolution plan approved. So generally, if you see speed of execution in IBC, is 3 to 5 years is a general time where from scratch to end, you have a resolution plan approval. In this case, that happened within your 18 months. So this is a remarkable case to reckon with. Now we come to some of the relevant provisions, and we will have a little bit questions in between. At the end of the session, we would have a very small case study for all of us to see an answer, to see whether you have really understood that and understood the concept. So there's section 370, which says who are the financial service providers. They say it means is the exhaustive definition. There is no other meaning except this. That means a person engaged in business of providing financial services in terms of authorization issued or registration granted by financial sector regulator. What does it mean? That you are providing some services of finance, but you don't have any authorization, then you are not providing a financial service. If you have a money lender in your township or township area who gives money, he is a financial service provider. But because he has not been approved by a regulator, he will not be covered here, whatever be his size. Now, who are the financial sector regulators? This definition is again exhaustive, means an authority and body constituted under law and includes. So they have given instances. These are the 4 ones, and other ones can be notified later. Who are the 4 ones? Are Reserve Bank of India, which generally takes care of banking sector and non-banking NBFC sector. SEBI, which takes care of your stock market. Insurance Regulatory and Development Authority, which takes care of your insurance business in India. And Pension Fund Regulatory Authority, which takes care of our NPS and the pension programs. So these are the 4 broader regulators. In a nutshell, in a layman way, we can say, is not firm truth that entities which are regulated by these 4 regulators are not within ambit of IBC. As I said, there are exceptions because we have to read the law between the lines. We will see how. But this is the general understanding, even of the course. We will see how. All right. Now, this is the most critical definition to understand what FSPs are. So these are financial services. What are those financial services? Section 316 defines that. What I have done, I have just tabulated it. So accepting of deposits. Banks, deposit taking NBFCs, HFCs. Right. Now my question to you is, as per this definition, if a NBFC is not taking deposit, will it be financial services? Will it be excluded? I open the forum for all of you, please. Your point of view. Mr. Rajiv, would you like to throw some light on this? Should I repeat the question? It says, if
Sir, the red one already have included in the red one. Includes.
Pardon?
Section 3, subsection 30 defines the term financial services as financial services includes. So accepting of debt, so if we are not accepting deposit also, we cannot say that this is not a financial service provided. Because this
So,
is
you raised a very valid point, and that compels me to come to a additional slide for you. I would like to invite your attention on the bullet point 2. So the section 316 is operated by rule of agestem generis. It means services must be of same nature or kind to be enlisted in section 316 to be considered as financial services. What does it mean? There it is written accepting deposits. You may say is not written you are not accepting deposit, that is not a financial service, is not equal. So accepting deposits, alternate of accepting deposit is taking money on interest. Is it? It is accepted deposit, right? So the rule of agestem generis has to be applied for section 316. Now, with this explanation, let's start the conversation again. Whether a NBFC, which does not take any deposits, would be called providing financial services or not, as per this definition. And let's presume that other clauses are also not applicable. Let's just focus on the clause A for the conversation. Yes, guys.
Well, ma'am, I just have a question. So, lot of NBFCs, they take loan from banks or financial institutions, and then in turn provide loans to
Correct.
end users. So, in a
Correct.
way, it is a public money involved, but
Yes, yes.
applicability of this, I'm not clear on. But yes, they in a way are taking public funds.
Correct, correct. So borrowing and taking deposits, accepting deposits would fall into that category. I agree. If a NBFC is borrowing money from financial institutions and giving loans, it would be tantamount to deposits only. It is a very fair interpretation. You are right. But there may be a situation where NBFC is rich enough, have got internal resources. They are not borrowing money. They are just granting, or might be they are not granting. They have some internal businesses only. In those cases, will it be will an NBFC? We are not talking other category. So name is non-banking finance company. Will that NBFC, if it does not take money, nor deposits, nor loans, will it be classified as providing as financial services? So my answer is no. As per this definition, is not. However, we'll see in subsequent slide. I have placed my comments at a couple of places. Even NCLTs and NCLET also at various occasions, once they hear that the applicant or the person against whom the case has been filed is NBFC, they just don't see anything. They just summarily reject the application because NBFC, they say law is not applicable for NBFCs. However, this is not right. This is not absolutely right. Only those NBFCs which are accepting deposits are called financial service providers. If you are an NBFC which does not accept deposit, you are a normal, the FSP regulations are not applicable. And now, recently, some of the NCLTs have taken cognizance of that and they have started giving treatment as NBFC, which is not a FSP, and they have accepted the application. This is the latest development of that. Okay. Now, moving on. If you are a depository, then is a financial service. If you do contract of insurance, you are an insurance company, so you are a financial service. If you are a custodian of assets of other person, then again, you are investment manager, is a financial service. And similarly, you have stockbrokers, investment advisors, intermediaries, collective investment schemes, registrars, underwriters. All these people are providing financial services and they are governed by FSP. But the beautiful thing is, out of all, only NBFCs have been notified to be covered under IBC. All other financial service providers, whatever we are seeing, are not within ambit of IBC. Therefore, let's say you have a stockbroker and you sell your shares. You have sold your shares. And the value of your share is say 5 crore rupees. Somehow your stockbroker does not give you that money. You say dues are more than 1 crore, then let me go to section 7 and file a case. Whether it would be accepted? Answer is no, it will not be accepted. When you go to the court, NCLT will say the stockbroker is governed by SEBI and is a financial service provider. Because a financial service provider is not covered in definition of corporate person, and there is no separate notification of that. Therefore, application under section 7 is summarily dismissed. Now, your question can be, what will happen? So, what we are talking is remedies under IBC. It does not mean that whole word has gone wrong. There are all other remedies available to you. The best remedy is that instead of reaching out to IBC, you file a complaint with the SEBI. Stockbrokers keep a decent deposit with their stock exchanges, and those deposits are maintained for the security of investors. From that deposit, you will get your money, and stockbroker would be penalized. So when we say these people are excluded from FSP, it does not mean that heaven has fallen here. What is there is only that IBC procedures will not be applicable. All other remedies available on the planet would be available. You are a credit card provider or prepaid instrument provider, that is also covered here. And this definition is inclusive. It means a similar services a similar services happens, which can be presumed to be included in the definition of financial services. Now, I have just spoken about it. I'm just is stated again in the slide. We just spoke on that. That is my view that non-deposit taking NBFC should not be considered as financial service provider. All right. NCLT piece we already discussed. Now, some of the NBFCs have started taking cognizance of this, and they are accepting it as a non-FSP and going ahead. So this is section 227 in a broken view. So what we see here is the section 227 is central government in consultation with appropriate FS, financial service regulator. What does it mean? That central government cannot issue regulation rules in isolation. If they have to tomorrow identify stockbrokers or depositories as financial service providers and want to cover an IBC, they have to discuss with SEBI. And after collaborating with SEBI, under guidance with SEBI only, they can issue rules on a particular type of FSPs to be covered in insolvency and liquidation proceedings of under the code. The section 239 empowers central government to make rules. Section 227 empowers to notify what FSPs are there. This is the empowering section for rules. Now we come on the FSP rules. On 15th November 2019, FSP rules were issued and applied in country. Now, these rules would apply as per the notification for the specific category of FSPs we just spoken a short while ago. Now there's a definition of administrator. In IBC, what we see that as a third pillar of IBC ecosystem, insolvency professionals play a independent role in the IBC proceedings by becoming a IRP, RP, liquidator, or bankruptcy trustee. Now, an FSP for financial service provider case, there is no resolution professional, there is no liquidator. This word is administrator. Now, who is this administrator? This administrator would act like IRP, RP, or liquidator. All right. But who is this administrator? The beauty is this administrator is someone who is appointed by the regulator. Regulator means RBI in case of NBFCs. And this person can be anybody. This person need not be an insolvency professional. Is not a requirement. It can be a bureaucrat. It can be an engineer, chartered accountant, finance professional. Anybody can be there. The only thing is it has to be appointed by Reserve Bank of India. Now modifications. As we see in section 227, this regulation, this FSP piece would be applied with certain modifications. So what are the modifications? Wherever word corporate debtor in the code is there for FSP, it would be replaced by word financial service provider. So when you read IBC for FSP, the corporate debtor means financial service provider. For the expression insolvency professional, IRP, RP or liquidator, it means administrator. So all the roles of insolvency professionals gone here, and who is the person who will take charge and act is administrator. Now under section 7, a financial creditor can file applications. Because one interesting thing is, under FSP, all the applications are filed with NCLT. They are presumed to be filed under Section 7. What does it mean? That Section 9 is not applicable and Section 10 is not applicable for FSPs. So, insolvency of a NBFC cannot happen because of operational debt, and NBFC cannot suo moto say that I want to go for a self insolvency. So it has to be Section 7 application. Now, who has to file? Section 7 application is filed by financial creditor. We all know that. But in case of FSP, it is filed by Reserve Bank of India, by the regulator. So regulator is not a financial creditor, but it would be filed by the regulator. So if I can draw your attention, when we were seeing this case of Dewan Housing Finance, it was RBI versus Dewan Housing Finance, because RBI filed the application. RBI was the applicant. The financial creditor piece, the role of financial creditor was played by RBI, because that application has to be filed by RBI only. Now, under Section 14, your moratorium starts when your application is admitted. But here is little different. Your moratorium starts from the day you file the application. So interim moratorium has been conceptualized here. So there is an interim moratorium which starts from that period of just filing the application. Because there is an interim moratorium, your business license would not be terminated. It is also mentioned in. So you file the application. It does not mean your license would be terminated. Nobody can terminate your license because you got an interim moratorium. Now, to help and advise regulator, because regulator would be a person, might be from different field, but may not know everything. So there can be an advisory committee. The advisory committee would be appointed by regulator. Again, Reserve Bank will appoint, and that advisory committee can be of 3 people or more, and that has to be done within 45 days of filing application. The administrator would be the chairman of the advisory committee. So it would be a kind of darbar where administrator would be sitting and 3-4 people as advisory committee members would be telling him, and he would decide what to do, what not to do. Final call would be of the administrator. Now, resolution plan. So successful resolution applicant, before filing the resolution plan, need to reach out to RBI and seek their blessings. Sir, can I file a resolution plan? RBI would say, okay, please show your credentials. We should check whether you are a fit and proper person to apply. If RBI says yes, you are a fit and proper person, only then you can file a resolution plan. Otherwise, you cannot. So ultimately, if you see who is playing cards altogether, who is appointing is regulator, who is appointing, RBI is appointing. Who is filing? RBI is filing. Who is constituting advisory committee? RBI is doing. Who is deciding who would be the resolution applicant? RBI is doing. So basically, it is all a Reserve Bank show altogether. One regulator, Reserve Bank of India, is handling everything under this process. All the other participants, let's say NCLT, they are the placeholders. They have a platform to run. So RBI is telling them that this is the application. My lord will accept it. My lord will accept it. RBI will say this is a resolution plan. We have agreed with that. The COC have also agreed with that. NCLT will say, okay, we agree with that. So it is all and all, out and out RBI show altogether. Now we come to a very important rule, Rule 10. Banking sector handle third-party assets. You take a loan, you have to pledge something. You have to mortgage something. So third party assets remain in the custody of banks. But bank is not the owner of assets. So Rule 10 gives a complete guidance on how the NBFCs would handle third party assets in case the application is admitted. So what is that? Number one, moratorium of section 14 will not be applicable to third party assets. What does it mean? You got a moratorium, all right, and you are not returning third party assets. Then it does not mean that third party cannot file a claim. Third party cannot sue you. They can sue you because that will not be applicable because that moratorium is not applicable to third party assets. These third party assets would be under control of administrator for the benefit of third parties. Administrator cannot sell it. Administrator would deal with those third party assets in the manner as notified by central government notification of 2020. Now let's see some of the glaring differences, and I would like the help of some of you in evaluating these differences and agreeing to it. So we'll go a little slow on this and it will clarify doubts if we have in our mind. So we are talking about our normal CIRP, then we are talking about a CIRP of FS. Application can be filed by OC, FC, and CD in normal case. In case of FSP, it is only by regulator, is not by creditor, is not by financial service provider, is only by regulator. Now, appointment. Now, who can propose? OC can propose, FC can propose, CD can propose, or NCLT can say, you would be my IRP or R. But in case of FSP, though final appointment would be given by A, but the person should be proposed by regulator, means RBI. So RBI will decide the administrator. Replacement. COC with 60% plus voting and replace a RP. Now A can replace, but only when we can replace, when a regulator, yani Reserve Bank when says, okay, this administrator need to be replaced, only then. Otherwise, nobody can enter. Operation of FS. RP can run in the organization as a going concern with a overall supervision of sales. In case of FSP, regulator will constitute advisory committee of 3 or more people and they will advise administrator and accordingly operations will be conducted. There is no concept of interim moratorium in normal CIRP, but we just discussed that in case of FSP, interim moratorium starts from the day your application is filed and ends on the day when your application is admitted. And then once application is admitted, your section 14 moratorium starts. License and all are not suspended in normal CIRP because of protection under section 14, except where there is a default in payment, right? But in this case, in FSP, it will not be suspended at all because it is given in rule and because of the protection of public at large, this rule has been framed out. COC can approve with 60% voting in case of normal CIRP for any resolution plan. But here, your 66% is fine. But whether you can be a resolution applicant or not, you need to take an NOC from the RBI, appropriate regulator. Only then they can apply, then you can evaluate resolution plan, go for voting by COC, and then present it before A for approval. In case of normal CIRP, you do not go to any regulator or IBPI to approve resolution applicant. Who can be resolution applicant? But in this case, in FSP, RBI need to check the fit and proper criteria. Without checking fit and proper criteria, you cannot get a NOC. And because you cannot get a NOC, you cannot be a resolution applicant. Now, this is very interesting for all of us. We all have to do a lot of hard work to qualify as a insolvency professional. You have to study, then appear for limited insolvency examination. You pass it out. Then you appear for training programs of about 48 hours or 60 hours. Then you go for registration, pay fee, get yourself updated among out of all the laws prevailing on the plan and all the fiscal laws to make it applicable. And then you exercise your wisdom as RP. But in case of FSP, your administrator need not be an insolvency professional. He can be of any educational background. He can be of, he may be IP, may not be IP. So for such larger case, it looks very strange because it is all done by RBI, but it looks very strange. Very matured professional group as insolvency professional have been left out here completely. Now, compensation to the members of advisory committee. So, whatever compensation question does not arise in case of normal CIRP, but in case of FSP, the compensation to the advisory committee members would form part of insolvency resolution process cost. Now, before moving ahead, should we have some question and answers here? So far, any doubt you have, you want to know a little more, or you have some questions unanswered? Let's open the house. Yes, please. Or should we keep the question and answer at the end? Okay.
Sir, is there any
Yes, please.
case RBI have appointed other than RP as an administrator?
No. No. So we will see one case, which is a predominant case of Diwan Housing, where ex-banker was appointed as administrator. So RP have never been appointed. Okay, all right. Now let's see some sharp differences in the process for liquidation. License and all continues in normal liquidation. In FSP also, they are not suspended or cancelled. When your section 33 is applicable, when CIRP fails. Gentlemen, Mr. Ajay, you want to contribute? Are you contributing to the session? Please, ask your question. What is your question? All right. In case of FSP, before issuing an order for liquidation, opportunity of being heard has to be given to the regulator, means RBI. So unless RBI indirectly agrees for liquidation, you cannot go for liquidation. RBI representatives would come to NCLT. They will present their case, why liquidation should be allowed or why liquidation should not be allowed. Only then A will give the verdict. Before that, it's not possible. Order for dissolution, again, In case of FSP, this order of dissolution can be given only after given opportunity of being heard to Reserve Bank of India. Once A listens to RBI, understand their arguments for dissolving or not dissolving, only based on that, A would decide it. Now we see some glaring differences in case of voluntary liquidation. So normally in voluntary liquidation, what you take a declaration from majority of directors under affidavit and under oath that they would be able to full pay debts, and intention is not to defraud any person. Now, in case of FSP, you need to take a prior permission of RBI for initiating voluntary liquidations. So there is no need of declaration from majority of directors and all. Once RBI agrees, all those things will prevail. Now, what happens? RBI, when they agree for something, they have their own documentation. All those documentation has to be fulfilled, and those documents need to accompany the prior permission, and those all things are filed with the A when you seek permission for voluntary liquidation. Order of dissolution is again you do the order under section 59, but here in FSP, before issuing the order, you have to give opportunity to RBI to present their case. Once they present the case, A agrees, RBI submits both pros and cons, and only then final decision is taken. Now, some of the cases. Can I take a break of 2 minutes? I'll be just back.
Yes, sir. Yes, sir, we can take break.
Yeah, just a 2 minutes break. Huh? Yeah, all right. I'm back. Should we start?
Yes, sir.
Okay, all right. So we'll see some of the judicial pronouncements. In this particular case of Randhir Raj Thakur versus Jindal Saxena Financial Services. This was before rolling out of Section 227. So in this case, application was filed against NBFC Mayfair Capital Private Limited. NCLT rejected the application. Then applicant filed an appeal with NCLAT. And NCLAT specifically said that because you are a NBFC, you are excluded in the definition of corporate person, and therefore we cannot admit that application. Another case of HDFC Bank, HDFC Limited versus RHS Holding Private Limited. NCLT dismissed the application on the ground that RSC was a NBFC, though RSC was a NBFC mainly in share trading, share investments, I should say, and they were not accepting any deposits. However, the application was dismissed. Now, this is one case which we will discuss something more on that also in subsequent slides, which is RBI versus Diwan Housing Finance Limited. This was the first case initiated under FSP. And, application filed in November 19. And in January 2021, e-border resolution plan approved. That was the speed of execution in this case. My 2 cents note there on outright rejection of NBFCs from a scope of court as a class in entirety is not justified. We have to refer definition of financial services, and as per the definition, non-deposit accepting NBFCs are not financial service providers, and therefore they are not excluded as FSP. So now courts have started taking cognizance of that, and now we see better light on this particular case. Now moving ahead. This is a very interesting case. So Diwan Housing was a very big corporate, and all the big banks, whether State Bank, Canara Bank, ICICI Bank, all were the lenders to Diwan Housing Finance. In 2018 and 19, they played around the money of people and were not able to, serve their debts. So people reached out to RBI, depositors reached out to RBI, and then whole thing was thought out that how to resolve this issue. So the Ministry of Corporate Affairs came up with an idea that why not to operationalize Section 227 and bring this legislation under IBC, because there was a framework available. Otherwise, RBI was not having a framework at all for insolvency. And that's how things spanned out. You got 227, then you got FSP rules, and then you got notifications. All these actions were behind this particular case. One particular defaulter, Diwan Housing Finance. So if you download this decision of Diwan Housing Finance, there are various decisions. You should download the first one. Each provision of FSP rule has been detailed and discussed in this particular section, particular order, and it has been done beautifully. Now, another important piece was that in this particular case, what happened? RBI superseded board of directors of DHFL and appointed Dr. Mr. R. Subramanian Kumar as an administrator. So we will see in subsequent slide, there's the word is superseded the board of directors. Let me just pinpoint you. is superseded. Sorry for this IT glitch. Generally, what we see that board of directors powers are suspended under IBC. Here the word is superseded. So in subsequent slide, we'll see how this works, right? So this appointment and the press release was also part of the order given by NCLT. And in this case, advisory committee was constituted, and details of advisory committee was also very beautifully given in the order. Ernst Young acted as a process advisor and AZB acted as a legal advisor. Now you see the beauty here. On a lighter note, in our practice under IBC, whenever you struggle with COC, COC's point is we say we need help of accountant, we need help of company secretary, we need help of legal advisor, we need help of process advisor. So a soft comment comes from COCs, what for you are? Why don't you look yourself, right? But when it comes to administrator in case of Divan housing, they took all the help. They had administrator, they have advisory committee, they have Ernst Young as a process advisor, and they have AZB as a legal advisor. So when it comes to a government machinery to resolve a problem, they mobilize all sort of resources, and which is required. But when it comes to an IP under IBC, there are always questions by COC whenever there is a cost incurred. So just on a lighter and softer note, I'm just mentioning this. So in this case, the administrator took help of advisory committee. They appointed EY as a process advisor with, of course, a hefty fees, or AZP as a legal advisor. As I mentioned, application under FSP is always filed under Section 7 of the. So this was also filed as Section 7 application by RBI, though RBI was not a lender. Why RBI? Because only an administrator, only a regulator can file the application under FSP rule, not the financial creator. This is a general exception. Because what we read is that Section 7 means application has to be filed by financial creditor. But here it is an exception that application has to be filed by a regulator. Now there's one brighter point for you here. Out of the lenders, there were depositors also. And count of depositors were more than 100. So they become class of creditors. Because they become class of creditors, as per the rules, as per the regulations, appointment of authorized representative become mandatory. And therefore, there was a role of insolvency professional in this case. Administrator suggested 3 IPs, and out of those 3 IPs, 1 IP was elected by the deposit holders to act as their authorized representative. So one AR, who was an insolvency professional, was appointed in this case as AR, and he acted and delivered his services there. Total claims were to the tune of 88,000 crores, huge value. Number of fixed deposit holders, 77,000. And also the one AR represented 77,000 people. You can think in those lines. The claim of FD holders was 5,375 and 40% belong to retail holders. Rest with the institutional lenders. FD holders got something 35%. Rest was a loss for them. So there were, I think, 50 plus resolution applicants who filed. Even Adani's, Reliance, all these big houses, they filed their application, they filed their resolution plans. The top three I'm just showing you. It was Oak Tree with a value of 32,000 crores, Piramal, with a value of 32,250, and Adani with a value of 29,860 crores. These were the top 3 months. And voting took place by COC. Piramal organization won the case, won the resolution plan. It was surprising because their value was a little lower, but however, it depends on the commercial wisdom of COC. So nobody can challenge. Though Oak Tree challenged this in court, they reached out to NCLT and NCLT declined to interfere in this case. So Piramal was the successful resolution applicant and they took over the organization in February 2021 after COC voting and everything. This DHFL case was challenged by Sasakawa India Leprosy Foundation. They challenged the constitutional validity of FSP rules and notifications before Delhi High Court, and Delhi High Court validated. They said these regulations are constitutionally valid and there is nothing wrong about it. And the case was dismissed. Now, another piece was because the old management of DHFL, we all understand there was a fraudulent intention, money was siphoned off. So, avoidance application for 30,000 crore were filed under Section 66. Now, question is who should take benefit of that 30,000 crore if recovered? So that recovery process is still on. I think Mr. Badhavan is behind the bars. He has been recently rearrested, though being on bail, when in another case. So 63 stakeholders filed application with NCLT that the benefit should come to the NCD holders. It should not go to PRAs. That is what their comment was. So NCLT have directed that they have to go by the resolution plan. Resolution plan is approved. Whoever is the beneficiary in the resolution plan for avoidance applications, they have to go by that. Because at every interval, NCLT also cannot disturb the overall IBC ecosystem. You have a resolution plan, it is approved by COC, then it is approved by indirectly approved by Reserve Bank and then approved by NCLT. Then our day-to-day interference is not permitted, not advisable. So they declined. They kind of dismissed the application. Oak Tree objected. So if you see the previous slide, Oak Tree was the highest bidder. And they said with the principle of natural justice, they should have been declared as bidder. So court said that this is a decision of people who are suffering. Who is suffering is the financial creditors. So if financial creditors of the view that resolution plan can be better handled and executed by a particular PRA, then it would be like that. There is no concept of highest or lowest. Even they could have voted higher to a person who is voting much lower, because it is ultimately the commercial wisdom of COC that prevails. Based on that, this litigation was closed out. Now, this was a very interesting case, again related to this. Dinesh Badhavan was one of the promoters, and he objected he said that issue was that in the meetings of COC, he was not invited. When he was not invited, he filed an application, an interpolatory application with NCLT, and prayed that he was the member of board of directors. He should be consulted. He should be invited. So what NCLT said? NCLT said, please read our instructions and earlier order. Reserve Bank of India has suppressed the board of directors of your company, of DHM. They have not suspended because you have been suppressed. You have been superseded. Because you have been superseded, you cannot enjoy any of the thing which has been provided under IBC, directly or indirectly. In IBC section 17, there is a suspension. But in this case, you have been superseded. Because you have been superseded, you are not entitled to attend board meetings. So, COC meetings. So basically, the flavor here is that along with IBC, Reserve Bank very aptly applied Banking Regulation Act and Reserve Bank of India Act, wherever they could find a loop. So what A said, the suspension is temporary, but supersession is permanent. Supersession is like a termination. So if you are terminated, there is no chance of restoring you back. And because there is no chance of restoring you back, you are not entitled to receive notices of COC meeting. You will not be consulted. You are no more directors of the corporate data. So forget about it. Third party assets. This is one very important notification, and we briefly touched upon. So all of you know concept of bailments, bailer, bail. Third party assets are kind of that. So I'll read out a certain selected portion of the notification for you. FSP as on insolvency commencement date is acting as a collection agent on behalf of third parties. The administrator will continue to discharge the obligation of FSP as collection agent and ensure the receivables in respect of such transaction collected are deposited and maintained in a separate bank account and are not merged with funds of FSP. So, administrator responsibility is, let's say there is a factoring arrangement and there are some receivables. The FSP organization realizes those receivables, that realization money they have to keep it in a separate bank. It should not be mixed up with the common pool. And whatever such deposits are collected, they need to be deposited and given back to the desired people in the prescribed manner as agreed. Now, question came, let's say FSP as a collection agent receiving some fee. What would happen then? So it is very well clarified through an explanation. That fee that you receive as a collection agent is your property, and that would be part of the common pool. It would be part of the asset of FSP. But if you are getting something on behalf of others, it has to be accounted for, kept separate. FSP as on insolvency commencement date has in its custody assets owned by its customers or counterparties and is under an obligation to return as per the terms and conditions of such contracts. Such administrator shall ensure that such assets are maintained in a separate and distinct manner. Distinct means clearly identifiable. It should not be mixed up. Capable of identifying them contract-wise and are not merged with those of financial service provider. It is an obligation to return or transfer such assets to the person entitled to receive in accordance with terms and conditions of the contract. The administrator shall not return the assets if there is a breach of the terms of contract And FSP has become entitled to retain such assets for itself and dispose the same to realize its dues. So to the extent of your dues, you can retain or realize, and beyond that, you have to return. There is no other option there. This would be my last slide on the conversation, and then we will attempt a case study. The present framework, as I stated, is only a band-aid solution, a stopgap arrangement. We don't have a full-fledged system, which we are looking forward. And I would say my and our, whoever is part of the conversation, expectation would be that the new government, when comes, settles down, they should work on it and should give country a beautiful framework. Might be within the IBC regime or otherwise, I wouldn't mind. But there has to be a comprehensive framework so that if there is a crisis, if some banks go for a insolvency, solutions are available. We should not be left at the mercy of bureaucrats at the end. I'm just stopping this presentation and adding another file. Just allow me a moment. Yeah. So is my screen visible to you again?
Yes, sir.
Okay, all right. So this is a very brief case study that I have designed to just see, how well we understand what we discussed, and if there are questions, we can do for it. So would somebody volunteer to read it out for me, for all of us? I hope it's very well readable and visible to all of you. Would somebody volunteer? All right, let me read. AB Bank Inc. is operating in India for last so many years. Recently, post-COVID, AB Bank could not maintain profitability, public solvency, and thus defaulted in paying to deposit holders and other vendors. Overall default in debt servicing was 800 crores. Not getting reasonable debt servicing, creditors got united and filed an application under Section 7 of IPC. In the application, they suggested Mr. IP as an interim resolution professional. Management of ABB Bank was in dilemma and engaged top legal firms. IP was of the firm view that all debts could be realized by a compromise and arrangement. Even contribution by parent of AB Bank Inc. could not be ruled out. Based on the above facts, please answer the following questions. So, is the case study clear?
Yes, sir.
Okay, all right, let's move on. Now, this is a question. Application under section IBC can be filed jointly by financial creditors and operational creditors. Evaluate the statement. You have four options. Which option is right? So, this question is in isolation. The question is application under section 7 of IBC can be filed jointly by financial creditors and operational creditors. Is it possible or not? Yes, guys. Can operational creditors join financial creditors while filing application under section 7? That's the question.
I don't think so.
Any other view in house today? So you are right. Section 7 is meant only for financial creditors. You cannot combine jointly with operational creditors. Even otherwise, Section 9 also do not talk about joint application by operation creditors, right? So both ways it has to be Section 7 for financial creditor. Can AA accept application under Section 7, notwithstanding AB Bank is an FSP? Now A knows that AB Bank is a FSP, financial service provider. Can they accept application? Options are yes, A can. Next is A cannot. C, A can accept once IBBI is aligned. B is none of them.
Yes, they can accept.
Why you say that they can accept application under Section 7,
If it is filed by the regulator,
but that thing is not given here. If you see the case study, in the case study, I'll just take you back. This is the case study. And the application has been filed by the creditors. All the
creditors.
united. So we have to give answer in light of the case that has been given to us. So what would be your answer?
Then no.
In that
No.
case, it is B. That is B.
Because
So,
FSPs are excluded from definition of corporate person, right? They are treated separately under Section 227. Only NBFC of 500 crore plus can be brought under IBC with RBI intervention. All right. If default by an NBFC is for 200 crores, can that NBFC be brought under IBC? The word here is default. What we should do? Which is the best option here?
Second one.
Second one. Any other point of view here? So you are right. Second one is the right answer. First one is definitely not the right answer. And C is definitely not the answer. D cannot happen because D is there. This is what I have. Now, let me just stop here from the presentation side. And my request to all of you would be that let's put our videos on and see each other and have conversation on the topic that we have discussed just now. Hope I am visible to all of you. So in case there is no question, then I would say, Anjali ji, are you around? Let me just call. I hope you found the conversation interesting today.
Yes, that was right. Actually, the problem is that we do not come across many such cases. So this
Of
is
course,
a
and
sort of new learning for us.
yeah, of course, because this is very isolated topic, if you ask me. Why it
Yes.
is isolated that in majority of cases IPs are not involved, and on this topic there is one large case which is of D1 housing finance. But this is very interesting to know because nowadays you will find some stockbrokers are defaulting and DP participants are not cooperating. All those things came into place, and when somebody reaches out to you, if you know you would be help the concerned person and make a case otherwise, or advise accordingly, so that person is rightly informed and updated. So, I think from ICSI side, nobody is there. So I would say thank you very much for patience hearing. Let's look forward to see you again on some other day. Thank you very much for patience hearing.
Thank you, sir.
Thank you.
Thank you. Thank you.
Yeah. All the participants, now the session has been ended. Now you can left for the